Situations where both you and your employer can discuss an employment-related settlement agreement and make negative comments about each other. Part 3. I'm Richard Hiron, also known as the Hironizer, and I'm an employment law solicitor. So the situation that we're talking about is what is known as whistleblowing, and the technical phrase for it is making a protected disclosure. Now, this is covered under Part 4A of the Employment Rights Act 1996, which essentially says the following about a protected disclosure, better known as whistleblowing. Firstly, to be a protected disclosure, it has to actually disclose information. So suspicions and evidence are not enough. It actually has to disclose a specific piece or pieces of information. So the second point is about the subject matter of the disclosure. So what the whistleblowing is all about. So it has to be one of these topics that we are going to go through next. So point A is if a criminal offence has been committed or is likely to be committed, or someone thinks that it has been committed or is likely to be committed. Point B is if a legal duty has not been met. So let's say that somebody had to file important information with HMRC and they didn't do that. That could be a breach of a legal duty. Point C is if there has been a miscarriage of justice. So say, for example, that someone has been convicted of a crime who shouldn't have been convicted of that crime. Point D is any danger to the health and safety of any individual. So say, for example, that there is a staircase that is dangerous in the workplace and someone either has had an accident or there's likely to be an accident, then that could tick that box. Point E is damage to the environment. So say, for example, that a worker knows or suspects that their employer has been dumping toxic waste in the middle of the countryside, or if they suspect that something like that might have been happening, then that could meet that situation. And point F is any effort to cover up anything that's happened in point A to point E. The thing with point A to point F is you don't have to meet all of them, but you have to show that one or more of them has happened or is likely to happen. The third overall point is that the worker must reasonably believe that the information that they have shared shows some kind of failure. So let's say, for example, a failure to meet minimum health and safety standards. And then the fourth and final overall point is that the worker must reasonably believe that all of this is in the public interest. That's quite a low legal test to leap over, but it can become quite tricky. There's no one hard and fast rule for what is or might be in the public interest, but let's just say that it's got to be something important that will be of interest to a large number of people. So I hope that sheds some light on whistleblowing and what it is, particularly in the context of discussing an employment-related settlement agreement and making negative comments. In the meantime, if you're finding a settlement agreement hard, bring it to Richard.